Good evening, class. We're back at it again. I've decided that I'd like to uh, do a little more lecture and get the Chapter 3 covered, Alternative Dispute Resolution. So I'm going to take that up tonight and get that out to you right away. This is an area, first thing I would suggest is that you take notes on this lecture because there will be questions on this. If there was ever a section of law that I'm going to emphasize, this is it. As I've told you before, I'm pretty passionate about it. And I'm passionate about it because the frustrations I saw in cases going in the civil court system had a lot to do with me deciding to get out of private practice and pursue other avenues of work because I just became so frustrated with the way our civil court system works. It is basically dysfunctional in that, as you heard me say the other night, the procedures, the process of a civil litigated matter can go on forever, and all it costs you as a business person a lot of money and a tremendous amount of time. And so really business people have been looking for alternates to the civil court system because it is so dysfunctional. Certainly it favors anybody with a lot of money, favors bigger companies against a smaller company. And so to my way of thinking, the way to level the playing field is to try to cause any dispute that may arise between you and someone else you're doing business with, to push them into arbitration. So they have to do arbitration and mediation. Now I'll refer to the two, mediation, arbitration, and I'll go through mediation with you first. But they go hand in hand in that the mediator is someone who gets together with the parties separately and finds out what their story is and what their objectives are, and then tries to work with those facts that he or she has to come up with the proposals that the other side might be willing to accept. And then the mediator works between the two parties, going back and forth with offers, makes suggestions to offers and whatnot, and tries to get the parties together to make an agreement between the two of them out of the court. The arbitrator is a different animal. The arbitrator is in effect the judge, and the parties have given him authority to act like a judge and make a final binding decision on the parties with respect to their dispute. And so that's where you'll hear the term binding arbitration. And you find that in more and more contracts today, business contracts and otherwise, because it's just too expensive. Makes no sense to get into the civil court system. Let me tell you a little bit about the political aspect of this thing and what goes on here. What has occurred over the past, I'll say 15 years, maybe 20 years, is that the bar has become polarized. And when I say the bar, I mean members of a bar, be it the Orange County Bar Association, the California Bar Association, the American Bar Association. Those are the major associations that lawyers will join. They'll join one in their county. They'll join one. They'll join the California Bar, and then they may also join the American Bar Association. And fewer lawyers do that. But what has happened is that in litigation now, primarily in litigation, you have we call it the plaintiff's bar, and on the other side you have the defense bar. And the plaintiff's bar tend to be lawyers who focus on lawsuits against larger defendants who have money. Now, in all fairness, there are many instances where the little guy, if you will, has been treated poorly by a bigger organization, and it makes perfect sense to bring a lawsuit against that larger corporation. But understand, of course, that large corporations are target defendants because they have money, something I mentioned the other night in my lecture. So the plaintiff's lawyers, they are looking for litigation. That's what they do. They file lawsuits. Now, as I said to you back then, the last lecture, they know that 95% of all lawsuits get settled. Now, that being the case, then they feel like if they file a lawsuit, they're going to get some money somewhere, because even the large companies now, this is where the expense comes to kind of hit them, is it's more expensive for them to go all the way to trial on a small case than it is for them just to pay a small amount of money to have it go away. And my daughter actually worked for a lawyer in Irvine when she was in college, and all he did was nickel-dime fender bender accident cases, and he made a living doing that. And for the most part, he never tried a case. He simply wrote demand letters to the insurance companies after a client would come to him because they were in a fender bender accident where maybe the property damage was $1,000 or $2,000, and then what they do is the plaintiff's lawyers, they send them to chiropractors. They don't send them to a regular doctor necessarily, often just to a chiropractor. And the idea is to drive up the medical expenses, because often insurance companies will use a formula of X times the medical expenses to come up with some figure they're comfortable with for pain and suffering. So you can get one of these little cases, and the person, maybe their car was damaged to the tune of $2,000, and they've been able to run up bills of, say, another $2,000 in medical expenses paid to chiropractors and other x-rays and one thing or another. Physical therapy is another big one to drive up the costs, and maybe they get those expenses up to $3,000 because they have a year to file the lawsuit. So during that period, they're helping their client get treatment, whether their client's hurt or not, by the way, because very often the client is not hurt. And so now you've got 3,000 medical expenses times 4 or 5. And insurance companies will often use a formula like 3 times those expenses, 4 or 5 times. So, and these lawyers know which insurance companies will pay what and how they calculate, kind of. And so he'll look at that case and say, well, that's 5 times my medicals is $15,000 plus $2,000 for property damages. So my demand is $25,000. And I'll settle the case for 17 or 18 or 15 or 12, because he's not going to court. So he's not going to have to do any trial preparation. So he's not going to have to do all these depositions and so forth. He's simply going to write demand letters. He might take a deposition that costs him $1,000 or $1,500. But basically all he's doing is holding the insurance company up. I would say in the majority of these kinds of cases, the plaintiff is not seriously injured. There are cases when people get hit from the rear and it snaps their neck back, and those injuries are serious, they're real, and they can hang on for a number of years and be very painful. And I understand those cases, and I'm fully supportive of lawyers pursuing those cases. But there's just a whole host of plaintiffs' lawyers who just pursue a case to make as much money out of as they can, and they could care less whether their client's hurt. They're going to push the medical expenses. That's the plaintiff's bar. The defense bar is usually the attorneys, usually large law firms, or not necessarily large, but they represent the companies. So they'll be hired by the corporate counsel for a company. They'll be hired to do the litigation, to do the defense work on the case. I think I mentioned to you we have a case going now with a corporation that I'm counsel for, in-house counsel for, and we've just hired an outside litigation firm to litigate a matter for us. But and those law firms tend to also be defense-type law firms. And these two camps really don't like each other. They're suspicious of each other. The plaintiffs think that the insurance companies and the big companies are trying to screw the little guy. They're cheating him one thing or another. And the insurance companies, lawyers, and the corporate lawyers all believe that the little guy is faking his injuries. He's not really hurt as bad as he says he was. He's making claims about injuries that he suffered in a business deal. They may sue Bank of America claiming they did something wrong in the way they processed one of his transactions, and so now he wants millions of dollars for it. So both sides are suspicious of each other. They don't want to cooperate with each other. And so the result is a log jam in the courtroom, and then all of this technical, procedural dueling and maneuvering that I explained to you the last time that comes into play. And so what's happened over the last 10 or 15 years, and maybe a little longer right now, is companies have decided that they need an alternative way to go have their dispute handled, to come up with a remedy, a decision on who's right or wrong. And that's the idea of alternate dispute resolution. We call it ADR, alternate dispute resolution. And it involves both, there's several other aspects of it. One is called negotiation, where they bring in a negotiator to try to negotiate. But the two major ones that I really want you to be aware of is mediation and arbitration. That's really the core, the meat of this topic and of ADR. And so what you're seeing happening is that companies are writing all, ADR provisions in their contracts. And so they're having arbitration clauses in their contracts, so that if you get hurt or injured or whatnot, you have to go to arbitration. You can't take them into civil court. And that's taken something away from the plaintiff's lawyers, because they know they all get settled. They know that most of the bigger companies would prefer to pay you some money and have you go away. And now the risk is not as great for them, because they can go hire a lawyer and spend 1/10 of the money they'd spend for a full-on trial to have a lawyer go and represent them in arbitration. So they are now putting arbitration clauses. Now there's some of the big target defendants are doing this as a matter of course. And in fact, the next time you go to your doctor, very often they'll have you sign the various, do the paperwork or sign some of the forms. And you'll note that one of those forms is a medical arbitration form, where you're agreeing to arbitration if it comes to malpractice. If you want to make an assertion that a physician performed malpractice on you because he did something wrong, then you have to go to arbitration with that. Stock brokerage companies do that now for people who have brokerage accounts with them, because these kinds of things, if someone doesn't get the result they want in a medical case, right away it's the doctor's fault. If someone's dealing with a broker and the broker loses money, even though he sat down with a client and they made the decision jointly as to how to invest, he wants to sue the brokerage house because they've got a lot of money. Now, in those settings, you must go to arbitration. The credit card companies do it. They require you to go to arbitration. And so many companies do it now. And another area, which is a big area for companies, is in the area of employment law. So they require their employees to sign an agreement agreeing to take any employment dispute to mediation and arbitration. And many companies have put together their own mediation arbitration programs that meet the test of the courts with respect to fairness, level playing field, and so forth. So let me tell you what we're talking about here with alternate dispute resolution mediation. First of all, one of the reasons it's come about is the court congestion. So the courts are full of cases, and they don't move very fast, as you learned from my discussion last time. So they take a great deal of time. There are complex procedural rules, and so someone is always filing a motion to dismiss something someone else, the other side, did because they said they didn't follow the procedural rules. And you heard me take a text yesterday on, what are you talking about? You have a dispute. Where are the merits? Where is the one plaintiff saying what happened as far as he's concerned, and the defendant saying this is what happened as far as I'm concerned, and some third party tell us who's right or wrong? Make that decision for us. I get my day in court. I get to say, tell my story. Okay, you'll spend hours and months in these civil cases because of the procedural aspects of moving a case through the system. Going hand in hand with that are the two other major things, and that is the time it takes and the expense. The expense is, as you heard from my examples yesterday, can be enormous, and often is enormous. And in that setting, a smaller business can't afford to do it. They can't afford to use the civil court system because they just don't have the money to do it and run their business. And the last area that is a very touchy area, particularly for the plaintiff's lawyers, because they were making a killing there, and that is this idea of punitive damages. And to give you an idea of punitive damages is a legal concept that says that if someone's conduct is so outrageous, so reckless, with such disregard for other people who eventually get hurt, then the jury may award them punitive damages, award the plaintiff punitive damages, which are the purpose is to deter from repeating the behavior and punishing that company or that defendant for what they did, that what their activities were that caused this injury. Now the problem is that in the United States until recently, punitive damages awards were totally out of control. Now most of you, I think, or many of you, probably heard of the famous McDonald's case, where the lady went to McDonald's, bought a cup of coffee without the lid on it, put it between her legs in her car, and drove out, and either had to slam on the brakes or spun around a corner too fast or whatever, and the cup of coffee spilled into her crotch. Now, McDonald's serves her coffee hot, and she was terribly, terribly burned. Now, let's just suppose her medical expenses were $20,000, right? Let's suppose she lost work she was out of work for a month, and she made $3,000 a month. So she's got $20,000, $3,000 in medical expenses. That's basically it. Okay, so she had a case with a medical expense, what I'd say $25,000. Now what happened is her lawyer made a claim for punitive damages, and he pointed the finger at McDonald's and said, "You have been so reckless and so disregarding the safety of your customers that we're entitled to punitive damages." And what set up a huge uproar, because the press, of course, loves to report these big things, was the jury awarded $4 million in punitive damages. $4 million. So basically on a case with $20 million in medicals, and what did I say to you, 4 or 5 times the medicals maybe, so $100,000, that is assuming you can prove liability, assuming that a jury will say that McDonald's is liable for that. And I get many of my students say, "You have got to be kidding me. Let's use some common sense here. This woman takes a hot cup of steaming coffee, puts it between her legs, and drives off in her car, and it spills on her, and it's McDonald's fault?" Well, in that case, it was. The jury found in favor of, I think her name was Lubeck, found in favor of Mrs. Lubeck. And what you don't hear then after that is that the case was finally settled for about $600,000. And there's another part to the case that I'll just, to round it out and give it a fair discussion. The plaintiff's lawyers were very clever. They were very astute. What they did is they brought an expert in the restaurant business, food service business, someone with a lot of credentials and so forth. And they testified that it's customary in the restaurant business in terms of serving coffee to customers that the coffee should not be any hotter than 130 degrees Fahrenheit. Okay, 130 degrees, that's what it should be, standardized in the food service industry, serving coffee to customers. Turns out that McDonald's serves their coffee at 160 degrees Fahrenheit. I can recall, I don't recall it quite as much now, but I can recall McDonald's coffee was always hot, and I happen to like real hot coffee, so it didn't bother me that much unless it burns my tongue. But I recognize that they did seem to serve their coffee very hot. On the basis of that, they made an argument to the jury that that was negligence because it was outside the standard norm of 130 degrees, and there were no warnings anywhere. They didn't warn the people. That's another part of this idea of finding big companies liable for things, is that plaintiff's lawyers say you should have warned the customer. Well, if they couldn't foresee what was going to happen, how are they going to warn them? But in any event, they decided that the jury found that McDonald's was liable. They awarded the $4 million. Of course, McDonald's, with all their money, appealed it, and they would have appealed it to the U.S. Supreme Court if they could have. And the woman eventually settled for $600,000 because she wanted the money, and she was going to wait. A case like that could be in the courts for 5 or 6 years, and I don't know how old she was. But here's what McDonald's did. If you go to McDonald's now and buy a cup of coffee, you'll see that they put hot on the side of it. Really hot. Like, are you kidding me? It's hot. No kidding, it's hot. So there's a book written by a judge in New York called The Death of Common Sense. And he's speaking about these kinds of cases where a jury goes in and says, I think McDonald's is wrong. Well, what they really think is McDonald's has got a lot of money and they can afford to pay. And that's basically what you've got here. Now, I've kind of gotten off on that as one of the last bases for arbitration and mediation taking such strong hold. But here's what happens. In an arbitration clause, you can put a provision in there that says there will be no punitive damages. You will not get awarded punitive damages. So what are you left to be awarded? Well, first you have to prove your case before an arbitrator. And then you can be awarded your lost earnings, your property damage, your medical expenses, and a reasonable amount of additional money for your pain and suffering. But you can't get punitive damages because for years there was no limit. The sky was the limit. And you would read in the newspaper all the time stories of lawsuits brought against big companies where the jury came back with these $150 million verdicts on some minor kind of injury or whatnot. But the juries just were, this is a big company, they've got money. So, let Target, someone slips and falls in a Target and breaks their arm, let Target pay. And so what the plaintiff's lawyers do, just to give you a quick idea of it, is you have a company like Target, let's say. Well, they'll get out their financial statements and have them blown up on these huge white boards that look like 4x8 pieces of plywood, and beautifully printed out and it'll have Target's financial statements on it. And it'll show that Target had $10 billion in revenues. And it'll show that at the end of the day, after paying all their expenses and taxes and so forth and so on, that they made $2 billion that year. So what the lawyers do for the plaintiffs is they've got these big boards and they say to the jury, the defendant was so reckless, I'm entitled to punitive damages for my client. And they need to be punished and deterred. Now, if you award my client $1 million, they made $2 billion. Is that really going to punish them? Is $1 million going to really bother them at all? I mean, they spend that in a month for soda for the workers. So if you really want to teach them a lesson, then you need to hit them hard enough that the $2 billion is affected. And because of that, you'll get juries coming back with $100 million, $50 million, $75 million, because they say, well, the lawyer said they make $2 billion a year. What's $150 million to them? And until recently, the Supreme Court finally came out and said that punitive damages have to reflect the gravity of the injuries and just how bad the conduct was. So basically they're saying they're not necessarily just to punish, but they've got to be reasonable. You're punishing, but they've got to be reasonable. And they've kind of in their opinion said that about 9 times medical expenses, for example, or compensatory damages is considered to be within the range. So, our McDonald's lady with, let's say, $20,000 in medical expenses, then you're talking about $180,000 or $200,000 in punitive damages, and then you've got the pain and suffering as well, which might be 3 or 4 times. But the idea is the Supreme Court's finally said this is getting to be out of hand, and it is because you get these big judgments against Target or some big company. And everybody else says, oh, well, they've got it, they can afford it. Guess what? The price of the goods that you're buying at Target just went up. You don't think they keep accounting records of everything they spend and everything they have expenses for? And if all of a sudden they start getting hit for $300-400 million a year in lawsuits, you don't think their prices aren't going to go up? You think they're just going to give that money out and, okay, we're a great charity here and let's hope we make money? The prices are going up, and that's where this thing's got out of hand. Because the punitive damages award's got to be huge, $100 million, $200 million, $300 million against a company. And they had to raise their prices. And so who gets hurt? Us, you and me. And some Joe walks away with whatever he gets for that kind of lawsuit. So along came mediation arbitration. Let me tell you about mediation. First of all, I've been a mediator. I am a mediator for the Superior Court, in the Small Claims Court, and the Limited Jurisdiction Court. And what mediation is about is you sit down with the two parties. They tell you about their case. They tell you their story. They are advised that you're not going to give legal advice. What you're going to do, you can't force them to accept an agreement. It's all voluntary. But you'll listen to their stories. You will be completely neutral. You will look at their stories, and then you will try to come up with some structure that can allow you to settle the case. Now, small claims court was a great training ground for me. I've done arbitration and mediations for larger sums of money, 10 million, 5 million, in the insurance industry that I come out of, in addition to my legal background. But small claims court was a great place to learn the techniques of mediation, because they apply to most anything. And what we found, the maximum dollar amount you can win in small claims court is $7,500. And if it's two individuals against two individuals, if it's companies, it tends to be about 5,000. Sometimes, under some circumstances, it can go 7,500, but not more than 7,500. So that's the total amount at risk here. And so what we would do in Superior Court is they would call the list of cases, and every morning they'd have about 20 cases. And out of those, about 5 people would not show up, so they'd have 15. And out of those, 3 or 4 would get settled, and so they were off the docket. And so you might end up with 7 or 8 cases left. Okay, you'd have continuances and so forth. You might end up with 7 or 8 cases left. These people are all offered mediation. They come in and they sit down with a mediator. I'm a certified mediator. You have to be trained to do it. The training is a lot of fun. And by the way, you don't have to be a lawyer to do it. So if you had any interest in doing it, you could be trained. There's various organizations around that provide mediators for free. I didn't get paid to do this. I did it to learn how to do it, and just because I thought it would be an interesting experience. But you get your training, and then you are certified to become a mediator. And so you listen to what the people have to say, and then you start making suggestions. Okay? Here's what we've discovered. We usually get 80 to 90% of these cases settled in mediation. Okay, now you can imagine if you take that and put it in a big case, or a case like my client has now, my company that I work with, that's suing for $125,000, and the other side wants $70,000. Those aren't huge sums. I mean, they're a lot of money to me, and I'm sure to you, but they aren't huge sums like you get in larger business transactions and disputes. But in that setting, you can take that to mediation, and you have a darn good chance of getting it resolved, of getting it settled. An 80 to 90% chance. That's been our success rate. And the reasons are these. One, with mediation, each side gets a chance to vent. The most common reason for a lawsuit is because the parties stop talking, because somebody gets really angry at the other person, and it's one of these "I'm going to show you" kind of things. And businessmen need to keep in mind that you can show them all right, and you can go to civil court and show them, but the lawyer's going to help you show them by you paying him 40 grand or 20 grand or whatever the amount might be. Whereas if you go to a mediator, if you go to, in a large case, you go to a company that does this, which I'll talk about in a minute. But in any event, it's the same concept. So you get a chance to vent. You get a chance to tell your story, which has a cathartic kind of effect on a person. And then, so you tell all your story. I'm taking notes. I'm asking you questions. And then the other side tells me their story. Now, in Superior Court, because of room, we end up having them together, which is a little tricky. I've done some mediations and mediations with some larger companies that do it with bigger cases, and we put the parties in 2 separate rooms. So you have the attorneys and the parties in 2 separate rooms. It's more effective because then they, excuse me, they can't see each other and so forth, and they don't hear each other and that sort of thing. But we're able to keep these mediations, even with the parties face to face, keep them civil. Excuse me, and I don't have any water tonight. And so the idea is that mediation is a non-adversarial environment. What I'm constantly preaching is to both sides is you don't want to go to court because you don't know what's going to happen. You don't want to go to court because the judge may not like your case. You may not want to go to court because this judge tends to be strongly in favor of tenants instead of landlords. And so you put a doubt in their mind that they're better off trying to get it resolved in here than going into court. Because many people haven't been to court before, and they're a little frightened about it, and they're uneasy about it. The reality is, however, I will say to you, any of you who are listening to this, that there is no reason for you to be that way and feel that way. And you're given a total fair opportunity to state your case before the judge if you end up going before a judge. And if you're prepared with your documentation and have rehearsed what you want to say, it's a very painless way to go and get your dispute resolved by a judge. A very important thing for you to know about going to small claims court. Lawyers are not permitted. So you will not be going in against your defendant to walk in and he's got his lawyer there. They are not allowed in small claims court. It's the most basic of the court system. Two people with a dispute in front of a judge telling their story. The judge doesn't get all hung up on a whole bunch of procedural evidentiary rules that prohibit evidence from coming in. He lets everybody have their say, asks questions, and makes a decision. Okay? So that's if you go there. Most people don't want to. They're happier settling. I've actually had them thank me profusely for getting it resolved, both sides, at the same table. So you can see that mediation has a tremendous advantage. What I do in my contracts for my clients is I put a combination mediation arbitration clause. So what I say is that the parties have to go to mediation first. And if they can't, and they have to get the mediation organized and ready to go in 15 days, and if they don't reach a resolution within 30 days, so a total of 45, then either party may automatically insist on arbitration, which is where you're now going to go to an arbitrator. Generally, they tend to be lawyers or judges, I would say 95% of the time. And you're going to go there and you're going to have a binding decision made. But prior to that, you've got the mediation. So I always want the parties to try the mediation first. It's helpful. You get a sense of the other party. You get some sense of the evidence that's going to come out. And so it's kind of can be a dress rehearsal, but it can be very fertile area to settle a case. Very fertile. And here's how we do it quickly. Let's suppose the claim involved is $6,000, and it doesn't even really matter much what the point is or what the item was. It could be a defective product that someone sold or whatever it might be. But I'll go to the plaintiff and I'll say, look, he doesn't want to offer you much of anything. I need to know, will you take less than $6,000? And if so, how much? Now, if they start off, I don't know, I'm not going to, this guy's a this and a that, and so forth and so on. And I'll say, look, you have control now. You're going to decide how this case comes out, you and your opponent. If you go to court, neither are you going to decide. The judge is going to decide. So would you rather have some control over it? So he might say, well, I might take $5,500. And I'll say to him, okay, now, do I have your authority to tell the other side that you'd make that offer? Or do you want me just to know that, and I'll go in and try to see what I can get the other side to come up with? And it can work both ways. It tend to be, don't tell them the first couple of rounds until you get down towards the end. So I go to the other side, and I've looked at his case, and I see the strengths and weaknesses of it. And I'm not giving legal advice, but I'm saying, John, it could be really hard to show this, to prove this. I said, this document looks a little weak, and you might make it with it, but I'm not sure. And by the way, what's the minimum amount that you would be willing to pay to get rid of this thing? Give me a number. Give me what your idea. And sometimes they'll ask you, as a mediator, you have to say, that's not my job. I'm not permitted to do that. And so he will say to you, well, I don't want to. Guy's a bum and this and that, but maybe I'll pay him $2,000. Okay, so now I know what I've got. I've got $5,500 on the one side, and I've got $2,000 on the other. And now I start to work them. And I work them with the facts of the case. I work them with their personalities, and in a positive sort of way, in a helpful sort of way, in a neutral sort of way. I don't take sides. And I do flattering. I'll say, you're a sharp businessman. You know that these things never come out the way you want. Make a business decision here, I'll say to one of them. Don't make an emotional decision. Make a business decision. We're talking about money here, just money. And so maybe I go to the other fellow who wants the 6 and said he'll take 55, and I say, look, he's made an offer, but it's much too low, because I know it's too low. But I'll say it's $2,500, because what I don't want is the guy to throw his hands up and say, forget it, I'm out of here, let's go to court. Most times they really don't, but you never know for sure what they're going to do. So I'll come in and say, I've got authority to offer you $2,500. Now I know that's probably not what you're looking for, but he's up to $2,500. You came down $500. He didn't want to give you 0, which is why you sued him. So where can we go from here? And so you work. He maybe comes down to 4. The other guy goes up to 3,000. Now you've got the plaintiff comes down to 3,800. The other guy's at 3,000. You can do all kinds of things. Split the difference. Why don't we split the difference? Sometimes you can go in and say, look, the defendant will give you $3,200 cash now. If you'll take $3,200 in cash, you'll get the money in 2 days. Certified check, cashier's check. Well, a lot of times, now he's discounting between 38 and 32, $600, but now your plaintiff's saying, now they're starting to feel the money. Because right now he has 0. And I certainly remind him of that. You have 0. So that's the way you can work them back and forth. Another way is, okay, he'll pay you the $3,800, but he needs payments. So, and then you can go all over the place with that. He'll give you $1,000 now, $500 a month for the next 5 or 6 months until it's paid off. And now you're going to negotiate that. How many payments are there going? How big's the first payment? Should be 1,000 or 1,500 or 500, and the payment's going to go up an extra 300 every month until you're paid off. Those sorts of things. And then what we do is when the parties finally agree, and let's say they agreed on a cashier's check for $3,200, then I write it up on a piece of paper. Doesn't need to go to a lawyer. Doesn't need to have the fancy word processing stuff and that sort of. You write it up on a piece of paper, and often you handwrite it. You read it to both sides. They look at it. They agree with it. They sign it. You take it to the court. You all walk in together. You give it to the judge. The judge has them come in front of him. He says, I have this agreement, this mediated agreement on how you're going to settle your case. And he explains both sides their rights about it. This is a binding contract now. You have to pay this money. If you don't pay this money on time, then the plaintiff can come back in and just get a judgment against you and then send the sheriff out to levy on your bank account or seize your car or whatever it might be. And our results are that we get 80 to 90% of these mediations, of these cases resolved at mediation. And of the ones we get resolved at mediation, say 90%, about 97% comply with the contract, with the mediated agreement. In other words, once you get it into mediation, it's done. Why? Because the parties agreed to it themselves. They don't feel like, well, their lawyer pushed them into it, or the mediator, if you're good, they're gonna see you as a neutral, and they are really going to be happy that you came out and did that for them because they couldn't get there themselves, because they had let time go by. They got extremely angry. They're not thinking clearly as business people. And the whole idea is, I want my money, I want my money, I want my money. And the other guy, I owe you nothing, I owe you nothing, I owe you nothing. And in the sobering reality of what's going on, eventually both of them say, I got to pay him something. And the other guy says, I'm not going to get 6,000, and I don't want to take a chance I'm going to get nothing. And they end up entering into a mediation agreement. And this can work at all levels. It's not, and here's the other part to mention to you in mediation. There are mediators now. Now this is the exception, okay. Most mediators now charge between $300 and $450. I'm sorry, $300, $350 to about $450 an hour. Okay, but a mediation can take, in many instances, they only take 2 or 3 or 4 hours. They rarely take more than that. Even large cases where the plaintiff is suing for $1 million. I've sat in on those mediations and watched the settlement come together in less than 4 hours. So now you spend $16,000. Now in the larger mediations, you have an attorney there. So there is an attorney for both sides. But they're looking to you to see if you can't get this case resolved. Because remember, most lawyers don't want to try cases. It's a lot of work, a lot of time, a lot of stress, and so they just as soon get it settled if they can. So that's the idea of mediation. Now, a couple other things about mediation. Number one, it's confidential. Nobody knows what went on in the mediation room. I am not permitted to tell anybody about it. A judge cannot come to me and say to me, I'm directing you and ordering you to answer my questions about what was said in the mediation. He cannot do that. Okay, that's against the law. He's not permitted to do that. So it's totally confidential. So no one knows what went on in the mediation room. Okay, the big one is it's non-adversarial. It's let's come together. It's a let's get to the point where we can sing Kumbaya and hold hands. The whole idea is to try to get together. Now, that's not to say that everybody comes out pleased. But a good negotiation, a good mediation is where everybody's not completely satisfied. Because if one party is completely satisfied, the other one is not going to perform. You cut too fat a hog. So in any event, the other thing is you select the mediator. So if you're doing a big case, like let's suppose we're talking about my client's case, the $125,000, $70,000 case, if we can get that into mediation, which we're trying to do, we're going to pick the mediator, and the mediator is going to be an experienced person, usually a lawyer, very often a judge. This was so popular, judges were making so much money, or could make money doing this, that many of them quit the bench, resigned as judges, and went into doing this full time because they were making $500 an hour, and a lot of them were in such demand that they could do mediations all day long, 5 days a week if they wanted to. So you tend to get retired judges, and you get lawyers who have got expertise in given areas. The fellow that I worked with had spent 30 years doing personal injury work and did large cases and so forth. So he had a 30-year reputation among the plaintiff's bar and among the personal injury bar, where people are injured, automobile or what have you, in industrial action, whatever. And he had such a good reputation that he was often selected by both parties because he knew what he was doing. He knew how to value a case because he'd done all those kinds of cases. He understood the more complex medical terminology that's used by doctors to talk about how they're treating a patient. So in any event, so that is the idea of the mediation. It is fast. You can see how inexpensive it can be. And the big plus is the parties do it together. They come together. Now, you can actually do a mediation in like my case that I'm talking about now, that I'm using as my example. We could go to mediation. We can write that up, sign it with a provision that says that we're going to reduce this to typed writing, to writing. One of the lawyers will write it, and the other one will look at it, and they'll agree that that states the situation clear enough. And based on that, you'll have your mediation, which now becomes a binding contract. So let's suppose the other fellow says, and the way this case could easily work out is we acknowledge we owe him $5,000. So he wants $70,000. We did lose $100,000 in potential profit because they threw him off the job. And when they threw him off the job, we were thrown off the job. So we did lose $100,000. But our CEO is a pretty sharp business guy. And as a result of everything that went on and so forth, and he wants more work from the company that he worked with, he's willing to see if he can get some money out of it. If he can't, I would suspect that he'd be willing to give him the $5,000 and walk away. And that's the difference between $125,000 and $5,000. So these mediations can be very fruitful. They can save you a lot of money, and you do them yourselves. So you're less likely to breach the agreement and walk away. And once it's signed, it's a legal contract. So now there's no question of liability about it. Who did what? It's a contract that says that this fellow is going to pay our company $50,000, and that's the contract. And if he doesn't pay, we're not going back to why all this went on, why he got fired for not performing the job properly, and why we were then taken off the job because he was our sub. None of that's going to come back into play. It's simply you signed an agreement to pay $50,000, you didn't pay the 50. I'm going to give a judgment to McQuitty's client, and that's the way it works. So that's the idea of the mediation, and I think it's a great way to go. You're getting more and more of it all the time. And as I said, the trial lawyers are not real happy about it. They do it. Oftentimes they'll do it because they don't want to try the case. They want to get it done and get on to other things. I have a bit of a jaundiced view of that, I'll tell you. I mean, there are some attorneys that really feel their client is entitled to more, in which case they don't have to mediate. They can go ahead and go to trial if they don't want to mediate. Because you do have situations where it's not always mediate and then arbitrate. It can just be a mediation. The parties can voluntarily agree to mediation and go to it. And then they can still file their civil lawsuit if they want to. And you can also have civil lawsuits filed, and before they've gone past the first couple stages that you saw yesterday, the parties agree they'll go to mediation, see if they can get it resolved. So mediation can come into play most any time. let me talk about arbitration now. And this is, I really part company with quite a number of lawyers on this, I guess. And I am a little bit of a zealot about it from my own personal experience and the way I feel about some aspects of the law. But arbitration it's binding arbitration, so it means that some third party is going to make a final decision on your dispute. And it's not going to be a judge. It's not going to be a judge in the black robes and sitting up in the big bench and all that sort of thing. It's going to be a man or a woman sitting in a business suit or business attire, hearing the case in a formalized setting. A conference room very often is used, or a nice sized room, not a courtroom, but just a nice meeting room. And the arbitrator will usually sit at the head of the conference table, and the parties sit on both sides. Usually it's a large setting. And the plaintiff puts on his case, and the defendant puts on his case. But in the situation with an arbitrator, here's a couple things you get. Number one, the arbitrator is free to require such procedural rules as he deems necessary. And the idea is they are to be minimal. So you have minimal jockeying back and forth on an arbitration. You're going to have this guy short circuit all this mumbo jumbo stuff. Now you can have depositions, right? But the arbitrator can say, I only want these 3 depositions. I don't want any more, because you're going to give him a statement of the case first, and he can decide he doesn't want you to take depositions of more than 2 or 3 people. I mean, you can go out and take them, but does your client want you to spend that kind of money too? So you decide on who's going to be a witness. You decide on how much depositions are going to be taken. You basically decide how much discovery is going to be done. Remember I told you discovery is 50–60% of the cost of a lawsuit that goes all the way into trial. And almost all of it's done before you go to trial. So there you go, 60% of what you spent, and you spent it, even if you settle it before trial, is gone. Nobody refunds you any money for doing that. So your arbitrator comes in and he sets these rules, and then he hears the testimony. Generally speaking, he has 30 days to write an opinion. The 2 sides ask him to write an opinion. So he writes an opinion which is like a judge's opinion, giving his reasons for it, his legal reasons. And here's a couple things you must know, okay? The arbitrator may misstate the law or may make a decision that is contrary to some law, but he feels like it's the fair outcome. The losing party cannot appeal that. Okay, if he doesn't follow the law strictly for whatever reason. Why? Because again, we're back to tell your story, get to the merits, and let's come out with a reasonable result. And so arbitrators' attitudes tend to be, I'm not going to cut anybody off from saying as much as they want. And once I get all the information and evidence and I've heard the witnesses, then I'm going to make a decision. And he may ignore a statute that he can interpret 2 ways, and it might be that there's case law that the statute should be interpreted the other way. And that party can't go to the courthouse and file a motion and say that arbitration needs to be set aside because he misstated the law or didn't follow the law. That's part of what you're getting into with arbitration. That's also a reason why plaintiffs' lawyers tend to hate it. They don't like that. They want the case to go on. They want it to continue through this dysfunctional process. They make more money. It's that simple, in my mind. And I'm sure there are others who would attack me over that, but I'm telling you what, I think it's true. And I think most businessmen would agree with me that they think it's true. Now, you need to understand this too. An arbitration award cannot be overturned except for some of the following reasons. Okay, it can be overturned if there's a conflict of interest. So you'd have to show that maybe the arbitrator had done work with the law firm of one of the parties. Maybe his son works for the law firm as a paralegal. So anything that has the appearance of conflict of interest, that arbitrator has to disqualify himself. Or if it's later determined that that was the case, then the other side can go to the civil court and say there was a conflict of interest there. Okay. There's another thing called abusive discretion, where an arbitrator does something that's so out of bounds and over the top that it's really not fair. And a court will grant a new arbitration or vacate that arbitration and let the case come to civil court if that's what they want to do. A couple of others. If the arbitrator decides to hear facts about something that's not part of the arbitration, or he decides to decide something which is binding that's really not in the arbitration issues, then you can file an appeal for that because he's into an area he wasn't hired to do. So that's another reason why. Now the other thing is this: there's no stenographic record taken. So like I said, in a courtroom you have every word taken down, and when you do the appeal, all the testimony is on paper to read. In an arbitration, there's no record made. Nobody's taking notes of what everybody said. Again, it kind of is a more relaxed atmosphere. It's not quite as everybody's on guard all the time. I mean, they're on guard, and they would, expect them to be. But the point is that it's less formalistic. Procedural rules are significantly relaxed, and so again, it's very, very hard to overturn an arbitration clause. Now, the other thing too, though, is that courts will and often do order a party to arbitration. So you can have, it does occur, and I've had it occur, where the party signed an arbitration clause and the other side filed suit in civil court. So they filed suit against my client in civil court, and all you do is prepare your motion with a copy of the contract with the arbitration clause in it, file it with the court, go see the judge, he'll look at it. You may have a hearing and have both parties come in and say to the other side, well, why don't you think this arbitration clause is binding? And that party may give you one reason or another, and guess what? The judge is going to say, you know what? Did you sign this? Yes. Okay. Well, this is an arbitration clause. You knew what you were signing. It's a binding contract. Go to arbitration. And I'm dismissing this case. So you can force the other side into arbitration, even if they don't want to, as long as they sign an agreement to do so. The hearing itself is very similar to a court hearing in that you'll have perhaps an opening statement by the plaintiff's lawyer, and then you may have an opening statement by the other side, or he may wait. In most cases, he'll probably wait now because he's dealing with a judge, someone who's not going to get all emotional over some surprise that comes out. So you make your opening statements, and then you put your witnesses on, and you ask them questions, you put on your direct testimony, you ask them questions on cross-examination, and the arbitrator sits there and hears the whole thing, and he makes notes and so forth. They don't record, they don't tape record what's said, and he then will take all that stuff into account, all that data, information. You can present documents like in court, photographs like in court, all that sort of thing. So it's basically a court hearing without the extremely strict formalities. Okay. Now, there are a number of lawyers that don't like that because they think that arbitrators sometimes let too much testimony come in, and that they think sometimes the cases can drag on longer, which I kind of think is a false positive, if you will, because the arbitrator is going to make $400 an hour, so he may want the case to go 2 or 3 days, and so he's going to let all these witnesses come on and whatnot. I haven't heard a lot of that, although I did hear it for the first time from an attorney that we were involved in one of our lawsuits who were kind of on the same side of the table. We were talking about arbitration mediation, and that was one of his comments about the arbitration, that they can be longer. Well, you know what? So even if it's a day longer, say 8 hours, $400 an hour, $3,200 for that extra day, if you're in the civil court system, you're going to be 2 or 3 years before you get there, and then when you go to trial, like I said, the trial lawyer is probably charging you $2,500 to $4,000 a day. So what's the big deal? Not to mention, in a civil case in trial, a case that can be heard in 3 to 4 to 5 hours, or perhaps in 2 days, is going to take 2 days to 10 days in a civil courtroom. So who cares that the arbitrator takes a little longer? Plus, you've got to make the determination that the arbitrator's up to that kind of stuff, which I don't buy. I know arbitration work I've done. I want to get the case done. I want to get it finished. So I don't look at it as, boy, I can make a lot of money if I keep dragging this out. So I don't have much, I don't put much credence to that. Another area where arbitration is usually required is with real estate transactions. You'll see that the California Board of Realtors, in their agency contract that is signed with the person you hire to help you sell your house or buy a house, requires arbitration. So because it's another big area where a homeowner gets into a house and says, this is wrong, that's wrong, they didn't tell me, they lied to me, and all sort of stuff. The next thing you know, the real estate company's getting sued, the agents, real estate agents getting sued, his company and whatnot. Now it's arbitration. Quicker, cheaper, faster. Okay. I mentioned stockbrokers, finance companies. One of the complaints is that you remember the term stare decisis, where there's precedent that helps a judge come to a conclusion because he's following precedent, or he's supposed to, but judges with some frequency will go away from precedent. But generally speaking, they try to stay with it. In arbitration, there's no precedent. So that being the case, but the point is, so what? Here's this guy's story, here's that guy's story. You hear it as the neutral third party, and you decide who you think's right and who ought to win. Whose conduct was wrong and whose conduct was not wrong, and therefore how much should this party get? And who cares about precedent? Now I'm saying that a little on a flip side, but being flippant. But the reality is that I think you get as fair an outcome in hearing in arbitration as you do going to civil court system. And so I'll tell you a quick story. In one of my lives in business, I spent a number of years. I had a company. We did turnaround work. And what's turnaround work? My clients or my referrals came from banks and savings and loans and financial companies that had invested money in a company that was floundering. And I was asked by a bank to go into to this. Well, I take that back. I was actually asked by the owners. There were 3 founders, and they got into such a dispute and argument with each other that they couldn't run the business. And they'd already invested a couple of $1 million in this business. And a good trial lawyer friend of mine in Orange County came to me and said, I've recommended you as someone who can come in and turn this company around, or at least get it stabilized. Would you be interested? And I knew what I was getting into, so I said, yeah, I would be interested, because it's a challenge to try to get a business turned around and running properly. And so in any event, I went in, I became CEO, and I started running the business and so forth. And these 3 fellows continued to have problems with each other, but I was kept out of it for the most part. What happened then was it got so stormy. What I do when I do this kind of work, because once you get the company turned around or you get it going in the right direction, then you're going to work your way out of a job, because the company's either going to get sold to somebody, or a new CEO is going to come in to take it over permanently. And I have to decide, there's a possibility that I might want to stay and run the business. It just depends. But I always get a severance agreement. And so the severance agreement calls for me to be paid X number of dollars a month for so many months until I can find another job. Because if the company fails, then I'm out of job, and where I gotta have money to pay my bills. So in this setting, I had a severance agreement, provided them to pay me for 6 months $10,000 a month. So the total amount in coverage was $6,000. But when we put that together, I insisted on an arbitration clause. Okay, $60,000 is not a huge sum, but it's not a small sum. Not only that, I needed the money, and I had earned the money, because let me tell you, working for these guys for 3.5 years took about 2 years off my life. They were such difficult people to deal with, and I had so many round and round blowouts with them at board meetings and whatnot. And a lot of it was because they were trying to show each other up, forget about the business, which had some prospects for being a good business. In any event, we eventually, one of the owners came in, the kind of the lead guy, and told me one day, well, we're not going to need you anymore, you're fired. He didn't say I was fired, he just said they didn't need me anymore. And I thought, oh, well, I had recommended that they close the business. We'd invested almost $3 million into it by that time, and I just didn't feel we could get it going. And one of the reasons was that one of the partners was a lawyer who was in direct competition with what the business was trying to do. And it became clear to me that he was working both sides of the street, and the business was never going to make it. So I had told them that we should close it, and they kept going on for 2 or 3 more months. And then finally they came in and said, well, we don't need you anymore. You're costing us too much money. And I said, well, that's okay. I understand. I said, I'll help you wind the business down and so forth, and then you can, you can do whatever you want with what assets are left. And this guy, trying to slip out of the arbitration agreement for severance, said, well, we're not closing the business. We're just going to close this office. Well, I knew that was a total lie. I mean, of course they were closing the business. There was no one else to run it. All the employees were being let go. I mean, it was a joke, but this guy was kind of a slippery type who, by the way, I'd been advised about earlier, so that's why I had the severance agreement. And I said, well, okay. And so then I was thinking to myself, well, rather than get huffy, get up and get mad, keep your cool and see where this, see how you can keep yourself in a position, because I knew I was going to go after my severance pay. And so he didn't like confrontation a whole lot, and I said, well, you know what? How about if I just hang around for another month or so? The lease is up in the end of December. This was mid-October, and I'll just hang around, help you get everything organized to take out of here. You're going to transfer stuff over to. He was taking it back to his large office in Laguna Niguel, and I knew he was not going to do the business. He was just taking all the records down there. And so what he unfortunately did was he left me in the place for what amounted to about 2.5 months. And I gathered all the documentation, all the evidence, photocopied everything I could possibly need to make up my case. Not to mention all the employees I had hired, and they worked for me, so they were sympathetic to me. And so any help I needed from them I got. So we closed the business in December, and in February I went to my attorney, who I'd used before, and I didn't do it myself. The reason being, there's an old saying, the lawyer that represents himself has a fool for a client. And no truer words have ever been spoken, because I'm an attorney. I think I know what I'm doing. I think I know the case. I was involved in the case, but the problem was I was emotionally involved. That's why you hire a lawyer. He's not. So I sat down with my attorney. I gave him all the facts. I laid everything out. And you can imagine it was pretty thorough, because I am a lawyer, so I know what you need to prepare a case. And you know, he still came up with 2 aspects of the case that I had not thought of, that I could have been blindsided in if I had gone to the hearing by myself to represent myself. So he was worth every penny for that reason. So keep that in mind in terms of representing yourself, except in small claims. Certainly in small claims you should do that. So in any event, long story short, let me finish it up quick. $60,000 was our request. We were doing this through a for-profit mediation service called JAMS, which is an acronym for Judicial Arbitration and Mediation Services. They were the first private, sophisticated arbitration and mediation company. And so they got many, many large cases, I mean big cases. So mine was really pretty small, but they have a system that you go through. It works perfect, and they have what they call the streamline rules. So here we go. We did we filed for the arbitration the end of February. We got all the preliminary stuff, exchange of documents, so forth, done during the month of March. We went to the hearing, I think, towards the end of April. I think we filed in March. So towards the end of April, we were getting everything ready. We went to the arbitration in last week in May. Okay, now understand we started in March, so March, April, May. We're in court, so to speak. And if I were doing this case in the civil system, you know where I'd be, right? Not even past first base. Probably not an answer to the complaint. Okay. We're in trial. We're witnesses and everything in May. I went away on vacation with my family, took my family on vacation for a week or so. When I got back, we had a decision by the end of June. So 30 days later, the arbitrator gave out his award. I won the entire case. He gave me everything that I sued for. So here you've got a case, $60,000, small amount. My lawyer's fees were $6,500. That was a bargain. $6,500 is a lot of money, but it was a bargain, because I got the whole thing done in about 3 months. And then the surprising thing is the judge has the ability to add interest to the judgment, and he can put a few other things on, costs and whatnot. And when we calculated it out, I was really entitled to about $72,000, $73,000. And if the judge felt, if the arbitrator felt, and he was a retired judge, felt that that was that they had treated me the way they had, which, and it was clearly a bogus refusal to pay. I mean, the evidence was clear as the fingers on your hand. Then he is allowed to award other things within a certain limit. And so I was pleasantly surprised when one of the founders called me, not even his lawyer called me, and said, "We'd like to settle the case. And listen to this, will you take $68,000? And, I wanted to dance on the desk, but I said, well, let me think about it, because in a negotiation, you never want to jump too fast. And when I figured the whole thing out, I figured between my costs, my lawyer's fees, about $6,500, I was going to net what I was owed, which was roughly $6,000. I think I ended up with $60,004 or $500, and I took the lawyer in his office out for lunch because I'd known the girls and some of the guys there for a long time, and we were all pretty good friends. So they had represented me in some other business matters that I was involved in. So I came out whole, and I was fortunate, and it took about 90 days to do it. And so if you're a small businessman and you get into litigation or an argument over $60,000, or like this case, again, I'm talking about with our claim for $125 and their claim for $70, this is a perfect case for mediation and then arbitration if it doesn't work. It makes no sense for this to go to the civil court system, okay? But it's there now. He filed the complaint and has served us with it, and we had to go out and get outside counsel to answer the complaint, and I'm going to continue to try to get him into mediation arbitration because it makes no sense to go to a full-blown court hearing on this matter. So a couple of things too on the arbitration. The arbitration is an award the same as if a jury gave it or a judge gave it. Okay, so when the arbitrator issues his award, it's a binding matter unless those items I mentioned, conflict of interest, abuse of discretion, taking on issues that weren't part of the arbitration, those kinds of things, which are very hard to prove, fraud, okay, his decision is going to be binding and final. That's the big thing, final. And 30 days after it's final, you can file it in the courthouse and you now have a judgment that this person owes you, this business owes you $70,000. And you then can go to the sheriff and proceed to try to collect it by executing on his properties. Maybe he's got machinery, maybe he's got trucks. The company's going to have bank accounts, and you go and you have the sheriff levy on those, and hopefully you get your money out of those levies and so forth. So it's as if you went to court, the judgment's as solid as a jury would give you, and you do it in 3 months, and you can proceed to try to do your collection right away. I got lucky because, for whatever reason, I think the other side knew that their case was so bad. And by the way, you always give up something. The judge came out and gave me $73,000. He gave me that $73,500 interest, all the way back to the day they didn't pay me, and on and on and on. I mean, he gave me he threw the book at him. He gave me everything that I could possibly want. But of course, I had settled for $68,000, and so that award was not. I couldn't back out of that, nor did I intend to. So that's a real life arbitration story, and when of course I won, so I was pleased about it. But I didn't think there was any question that I should win. This was really a strong case. You have others. I had an arbitration involving the construction of a movie theater. It goes back 20-some years, and I thought I should have won it, and I lost it. And I actually lost a client. At least there were 3 partners, and one of them thought I was the worst guy that ever came out of law school. Well, we put our best case on we could, and we lost. And we lost for a good reason that we lost. And so I don't know if I want to defend myself any further here on YouTube, but the fact of the matter is, when we hired we threw the old contractor off the job and hired a new contractor. And I said to these 3 partners, now you can only bring this guy on, the new contractor, to build what you contracted with to build in the contract with the guy you threw off. Well, of course, what they did was they went in and they said, now we want this fancy tile instead of this baseboard stuff, instead of this synthetic wood, and we want these kind of fixtures, and all of a sudden we want these different drapes. And I said to them, look, this is before the arbitration. You can't. You're only entitled to what's in that contract. And of course they ignored me. So then we turn around and we sue them, and we sue them for everything because they're telling me I want to go for all this stuff. We spent it. That's how much it cost us. And guess what? We didn't get it. He got what he was entitled to for the actually he got what he entitled to for work that we hadn't paid him for, because he had done work and we probably hadn't paid him 50 or 60 grand, I guess, and he got that he got paid for that. And my guys were angry as hell at me, and and so I'm older now, and it affected me pretty bad then. You don't like to lose, but anyway, that's the way it went. So last thing, companies that have arbitration clause, arbitration programs, they'll have mediation arbitration programs for employee dispute matters. They have to be fair. They can't be one-sided. One of the cases that when I teach this, teach arbitration mediation as a separate course, and Hooters restaurants, I'm sure some of you may have heard of Hooters, they had a mediation they had an alternate dispute resolution program which called for mediation arbitration, and it was so horribly one-sided that we studied a case where the case got thrown out. It was a hostile work environment situation where a waitress, they wear scanty clothes anyway, but a waitress was getting slapped on the fanny by various patrons. She complained about it, and the manager said, "Oh, don't worry about it, it's no big deal." So then she filed suit against him, and she had an arbitration clause in there, and they forced her into arbitration. So she went into arbitration, and of course she lost. And they filed suit on the basis, then they filed suit again as an appeal to the arbitration award. And for example, this Hooters, kinds of things they were doing was, they could appeal the arbitration to the civil court, but you could not. They had a list of arbitrators that you could use. You couldn't pick your own. They already had their list of arbitrators. Well, who do you think they favored? And it just went on from there. And so that arbitration program was thrown out by the courts as being unfair. On the other hand, there was another company called Darden Restaurants. They were also a restaurant business, and they had a fabulous program. They had an ombudsman, which is someone in the company that meets with the person first, where there's a disgruntled employee. Then they would go to mediation, and then they could go to arbitration. And the parties had to jointly agree on who the arbitrator was. And believe it or not, in fact, they provided that if that the employee who was bringing the action against them, if she had to spend more money than 1 month's salary, they'd pay the amount of her fees. And you can't get more fair than that. So just keep that in mind. Companies put in these alternate dispute resolution programs, which will include arbitration mediation. They must be fair to both sides. And believe it or not, there are companies all the time that try to, lean these things their way and think they can get away with it, and many times they do. But these are two examples of where they could not. And so you have to understand that if you have a company, your procedure, your process has to be fair. So I think that's about all I want to tell you about arbitration mediation. I'm sure you realize now that I'm heavily in favor of it. The law that's involved with this is called the Federal Arbitration Act. The Federal Arbitration Act, I want you to know that. It's called the Federal Arbitration Act. And it's kind of the foundation for doing this, although all the states have similar acts. And that's what a lot of times the federal government will put a Federal Arbitration Act in place, and then you'll have the California Arbitration Act. They tend to run very similar, but there will be unique aspects to them. But their idea is to provide the process by which arbitrations are to be held. I mentioned that there are companies that do arbitrations on a private basis. The oldest arbitration company is called the AAA, or the American Arbitration Association, or the AAA. They've been around since the 1920s. They have huge panels across the country. They do mostly commercial types of arbitrations where you have companies involved in commerce of some kind, and the contracts can get complicated and whatnot, and they'll get expert arbitrators to come in to handle those cases. That's the American Arbitration Association. And then, as I said, the one that started right here in Orange County, called JAMS, Judicial Arbitration Mediation Services, was founded by a judge named Warren Knight, who just passed away recently. And he turned it into, it is the premier alternate dispute resolution company probably in the country, because they bought an East Coast company that was doing very well called End Dispute, and put the two together, and they are the major player in the deal. Although I did a lot of my mentoring with a company called Judicate West, which is in Santa Ana. It's also a very good, solid company. They're doing some arbitrations online now. Excuse me. And these tend to be the smaller ones. They tend to be internet issues. And what they'll do is the two parties, who are usually in different states, of course, and aren't communicating, they go into this online site, and the way it works is each party makes, it's like a bid situation, okay? He owes me $5,000, but I'll take $4. I don't want to pay but $1,000, but I'll pay $2. And then the online people try to go back and forth to see if they'll up the amount. Maybe they'll make a second bid. And if it gets within 30% of the original demand, then the parties agree it's automatically settled. So they do it online, minimum amount it's almost like a reverse bidding process. And if they can get the parties close enough, and they have a formula that says if you're within 30% of what the plaintiff wanted, then the case is settled, and the plaintiff has to accept that. If the defendant will come up to within 30% of what you wanted, so let's see, 30% of 5,000 is $1,500, right? So, if he comes up 3,700, then the other party, the plaintiff, has to accept that because it's within 30% of, or a third, I guess. Don't check me on my math, but I think you get the idea. And then lastly, you have international dispute resolution, and that creates some problems. And the larger companies that do international business will tend to put in an arbitration clause. They will then decide whose law will be followed. So you may have a company in France involved in a dispute with a company in America. Whose law is going to determine the outcome? Whose law is going to be followed? So most times that's determined already. And then now you've got a judgment in France against this company, but you have to come to the United States to enforce the judgment, to try to collect. So you've got this issue of nationalism. Are we going to let the French come here and tell us our American company has to pay $500 million for something in an arbitration that they lost in France using French law? And so the way most of this is worked out now is that courts with the various courts in the various countries, the Supreme Courts in most cases, if they don't find the law that was applied to the outcome totally contrary to American law, then they will allow the French company to come in and collect the money. And in most cases, many cases, that's the way it's done. So it saves a tremendous amount of money. You can imagine a litigated matter going between France and the United States. And these things are very complicated. They probably would have 10, 20, 30 witnesses. They would undoubtedly have hundreds of thousands of documents to peruse through. So international arbitration is something that's considered very valuable. Most major companies provide for it, and in fact it's worth their while to do it. So, okay, that is it for arbitration mediation. My recommendation to you as a business person, I'm looking at my time here, is that you have these clauses. They're very simple. I've got some sample clauses if you happen to want one, or a sample arbitration agreement and mediation agreement, which I'll be happy to send on to everybody or anybody. But you need to have them in your agreements, in your contracts to do business with people, whether you're doing a service or whether you're doing manufacturing or repair work, construction, whatever it might be. My belief is that you should have arbitration mediation clause in those contracts. And beyond that, I think you ought to have a similar kind of document for your employees if you have any sizable amount of employees. There is a caveat to that, though. The smaller the company, the less likely I see you having that. In fact, I would stay away from it. If you asked me to pick a number, I'd say if you have 20 or 30 employees, I'd probably stay away from it. The reason is and I learned this from a company I was general counsel for back in 2007 for quite a few years in Newport Beach. The owner was a tough guy, and I put arbitration clauses in some of our employment contracts, and he told me to take them out. And I said, why? And he said, because these employees, if we let them go, and he had a lot of turnover, he'd fire people, then they're going to have to go to civil court and pay a lawyer
$5,000, $10,000 retainer to sue me. So I'm not going to let them come to arbitration because they can come to arbitration for $2,000 or $3,000 or $1,000. There's some, merit to that, I guess. It's not unethical. So if you have a small company and you got 4, 5, 6 employees, you're less likely to be a target defendant anyway because they're not going to think you've got a whole lot of money. You have to look at your business and see how profitable it is and how much employees may think the company is valuable or is worth a lot of money. And if you've got 20 or 30 employees, you might want to do arbitration mediation there, or at least mediation. So in any event, I'm going to sign off now. We're about an hour and 20 minutes in. So this is the last piece, and you are going to need to see this. I'll send you an email also because this information will be on the test, probably emphasized. Certainly there'll be a lot of these key points I talked about. So know what arbitration and mediation is about, know what it does, know why it's better than the court system, and know the technicalities of can you enforce it, not enforce it. A written agreement is a contract now, and there's no question of how much money you owe. It's when you're going to pay it, and those sorts of things. So, and courts prefer it. Judges will often push the lawyers into arbitration mediation, often push them into mediation because it doesn't require an agreement. In that case, the judge can just say, I want you to take this case to mediation first before I hear it, because they want to try to get rid of it. Okay, that being said, I will be talking to you sometime next week.